Court does call the case of the people versus Charles Williams. Yes, sir. Your name, sir? You're a prosecutor.
What?
No. Take your time.
I'm so sorry. APR is with different people.
All right. He's waving.
Yes, Your Honor. You have to sign.
I do. Mr. Williams, you're waiving the right to a preliminary examination?
Yes.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Brown.
I'm going to bring on behalf of Charles waive and request retrial.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for April 9th, 2025, 1:30. Judge Conlon.
You guys bond.
Bound, continue.
Thank you.
Court does call the case people versus Mike Jones.
APR is with different people.
Go ahead.
Good morning, Your Honor. Assistant Public Defender Ben Dunaway. On behalf of Micah Jones, who stands to my right. Mr. Jones, would you state your name for the record?
Thank you. He's waving.
He is waiving, Your Honor. He is signing the form right now.
Sir, you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count. Counsel, your turn.
One date, Your Honor?
You waive reading of the information?
Yes, sorry, stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
April 7th.
April 7th, 2025, 1:30. Judge Hammoud.
Thank you, Your Honor.
Thank you. Bond continue. Court does call the case of the people versus Calvin Fuqua.
Choice grant on behalf of people, Your Honor. Rob Brown, Street on behalf of.
Your name, sir? Thank you. Is he waving? Okay.
This is the date and time set for examination. The officer involved is informed by the officer. Start off with the consent notice there, or today's date, he was built to appear to be part.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's on defendant's motion without prejudice. Thank you. Court calls case people versus Zenyi Yu.
Jones on behalf of the defendant, will state your name. Go up.
Thank you.
Today's date time set for preliminary examination. At this time, people are unable to proceed as count one and ask the court to remand on counts 2 and 3.
No objection to this dismissal.
Count one is dismissed. The case is remanded to the 15th District Court on counts 2 and 3. I'll set a pretrial date,
April 16th at 9 a.m.
April 16th, 2025. It's at 9 a.m. 9 a.m. before Judge Perry.
You've already given my client permission to go to California.
I did?
She returned for today's thing. She wants to return to California. She'll make her court case. Judge Perry usually allows that. So we're asking permission.
No objection from people.
All right. So she normally resides in California. Is that
After this today, Your Honor, she re-engaged with her mental health treatment, which is based in California.
okay?
And that is her permanent.
So what I will do is her bond will continue. Defendant may travel. And she resides in California, correct? Right.
Yes.
Okay. So I'm going to word it this way that she may travel and reside in California, must return for court dates or court proceedings. Of course, if Judge Perry allows something. Right, thank you. Court calls the case People versus Tamia Harris. Where is he? Was lurking around all morning. Next to him, Bernstein. You know where he is? Okay, gotcha. Appreciate it.
Bernstein on behalf of Ms. Harris.
Your name? All right. I had before me a plea form, and I'm assuming this was supposed to be an attempted. And it's okay. Huh? You messed this all up. Hold on. I don't know if my pack codes are. They're not. They're not. You did. Jeez, oh Pete. No, don't worry about it. I'll fix it. So I think how this is supposed to read, and now kind of does, that she's going to be pleading guilty to the charge of attempted resisting and obstructing a police officer, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, sir.
Man, what is one?
Where
You have gum. Check that. Oh. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. Is that correct? That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? All right. You understand also that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights from today, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on there for.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will and because you believe that you're guilty of this offense? February 8, 2025, at the location of 1490 DeSoto in Ypsilanti Township, Washington County, state of Michigan. Did you come into contact with police officers?
Yes.
What happened that makes you think that you're guilty of this offense?
I was interfering, obviously.
So somebody was being arrested. You knew they were being arrested and you interfered with that arrest. How did you do that? Okay. And you knew it was a police officer doing that, correct? All right, counsel, have I complied with the court rules?
Yes, sir.
Court will accept the defendant's plea to count 2. Plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
At 10 a.m. before Judge Washington.
May 15, 2025, 10 a.m. before Judge Washington. So when you grab the arm, how'd that work? Not well. Yeah, okay, just check it. Bond will continue. All right, thank you. Yeah, it didn't work out well because you're here. Then isn't figured that out on my own. Court calls the case, People versus Anita Payne.
They have no choice. We're gonna be met people.
Hello, my name is Anita Payne.
All right. I have before me a plea form that indicates defendant will be pleading guilty to attempted custodial interference or kidnapping custodial interference, the 6-month offense. Upon her successful plea to that charge, the kidnapping charge, custodial interference, would be dismissed. There's further the agreement, although, well, I guess it's me. It's okay to seek a deferral pursuant to statute.
That's all.
That's the court's full understanding of the agreement. Is that correct, Mr. Brown?
That is correct, John. Thank you.
Ever sworn.
So I swear, so keep the whole thing, but you know, we got. That's correct.
My name is Anita Payne.
Sure. Go on. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted kidnapping custodial interference. Is that correct? That is a misdemeanor punishable by up to 6 months incarceration and a $2,000 fine plus court costs. Is that?
Yeah.
All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes, sir. Oh, no.
All right, let's try that again. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge? Has anybody threatened you or coerced you? You're doing this voluntarily
Yes,
of your own free will
yes, sir.
and because you believe that you are indeed guilty?
Yes.
December 2nd, 2024, at the location of 4511 Packard Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have custodial possession of a child at that time? Physical possession.
Yes.
All right. And at the time that you had that physical possession of the child, was that child supposed to be returned to the other parent
Yes.
at that time? And had a 24-hour period passed?
Yes.
Since, I guess I should clarify that. The child was supposed to be returned at least 24 hours prior to the time that you got.
Yes.
All right. And you just failed to do so.
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, John. People are saying. It's
The court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be.
It's got a TV docket.
Sure, it could. I can put it wherever I want. No, what? You're saying that's where you believe it belongs.
April 1st at 1 p.m.
Sentencing will be April 21st, 2025, 1 p.m. And that's before me. Yes. I saw you sign the sentencing judge waiver and I didn't know why. Was he trying to like not have me? What was he trying to do? He was up to something. What? Oh, okay. Yes. All right. It'd be before me on that date. On your way out, you may want to stop by my probation department to get that started, that process, all right? What?
Or
April 21st.
Well, I was gonna set another date, but then Childers jumped in. So I set another date and you weren't listening. The only person that was listening was your client. Are you good, Navarro? Are you good? I know you're good. Are you good? Okay, bond continued. What? No, it's at 1. I don't know why I bother talking. Just like go. You got it? Finally? Ma'am, what date did he write down?
The 21st at 1 p.m.
Okay, good enough. All right. Thank you. Just double checking. Court calls the case of the people versus Robert Jones.
And then don't you have.
Assistant Public Defender, we have Mr. Jones. With motion now, Mr. Jones, statement for the record.
All right.
It is going to be no.
We have a form that indicates that the defendant will be pleading no contest to the charge of aggravated domestic violence, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. There is the agreement between counsel of no upfront jail. We don't do that, but you see that that's the agreement, understanding of counsel.
That's right.
All right. Is that a correct statement? All right, let's have him sworn.
Raise your right hand. You solemnly swear or affirm to tell the truth and whole truth. Yes.
Sir, it is his court's understanding that you are going to be pleading no contest to the charge of aggravated domestic violence. Is that correct? That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand it? Do you understand what a no contest plea is? Let me explain 2 things about it just to make sure. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Now, understanding all and the basis for the no contest plea is potential civil liability counsel.
Well, back in memory, this is about 5 years old.
Sir, to the charge of aggravated domestic violence, how do you plead?
No.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal over it. Are you on probation or parole? You are? Were you on probation or parole at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2416061. Any objection to the court having reviewed that report?
None from defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Defense is satisfied.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be, it's a DB.
April 21st at 1 p.m.
April 21st, 2025, 1 p.m. That is before me. Bond will continue.
Thank you.
Thank you. Sir, you may want to stop down at the probation department down the hallway and just check in and get it started. Okay, thank you. Court does call the case of People versus Cody Tournier.
And then on behalf of the people. Charlotte, second on behalf of Mr. Tournier.
All right. And what are we doing?
Your Honor, today's date comes up with preliminary examination. At this time, the people are unable to proceed as to count one and would move the court to add count three of telecommunications, now use domestic relationship and remand on count two and the added count three.
You want me to add in count?
Yes.
Okay. Count three is what?
It's the telecommunications now use domestic relationship. And then I have the pack from the court.
Oh, yes. Yes, Pat code.
750.540E1H. And it's a 6 month, $1,000.
E1H.
Yes.
Okay. That is actually count three. And Counselor, you waive presentation of the complaint on that charge.
Yes, we do. We have no objection to this consent.
All right. And your client enters a not guilty plea to count three.
Yes, Your Honor.
All right, very good. I'll enter that not guilty plea to that charge. There being no further further reading of that. Count one is dismissed. Set this for a pretrial.
April 10th at 2 p.m. before Judge Fresh Hour.
April 10th, 2025. What time?
2 p.m.
April 10th, 2 p.m. And that's before Judge Fresh Hour.
Your Honor, I'm not available at the time. I have a preliminary examination in Oakland County at 2:00. Is there another day?
Let me see if we have one. You may have to deal with Judge Fresh Hour staff. We don't have another pretrial.
I'm just checking it.
I'm thinking it's going to be a DV. That's a DV day.
Correct.
Okay. Good, we got one.
The next one would be the 24th at 10 a.m.
Work for you?
It does not.
Okay. Why don't I do this? But why don't I give you, so there's at least some additional time, the 24th at what time? 10? At 10 a.m. before Judge Fresh Hour. I'll let you then, that'll give you time to contact them.
I appreciate that, Your Honor. Thank you.
All right. Bond will continue. Thank you. Court has called the cases of the People versus Elroy Love. All three cases.
Santino, hearing on behalf of Mr. Love. Mr. Love, can you please state your name for the record?
What are we doing?
In order to end the date time set for preliminary examination, at this time. Numbers. Internet statute, can't pull up the file numbers. Do you need assistance? Yes.
Your internet now?
You're sending somebody over.
So hold it. Why is his working?
Find out how this works. That's
Why'd they give her the cheap stuff? Okay, it's just a patchwork of stuff. Okay.
oh, yeah. This. Mr. Small, I mean, these are hotels. Okay, Your Honor, as the case 23 F 1460, the people are unable to proceed as to count one, would ask that counts 2, 3, 4 be remanded to district court. And then, sorry. As the case number 23 F 1442, the people are unable to proceed as to count one and ask that count 2 be remanded to district court. And then the people are unable to proceed as to case 24 F 2 1557.
Okay. Okay, so let's start with In case ending in 1557, people being unable to proceed, counsel, you're moving to dismiss.
Yeah, Judge, we would be moving for dismissal.
People being unable to proceed in that case, this case is dismissed on defendant's motion without prejudice. Then on the case ending in 1442, count 1 is dismissed. The defendant continues his not guilty plea as to count 2. I will set a pretrial in that matter to DV. April 21st, 2025, 10 a.m.
Yes.
10 a.m. before Judge Washington. And in that matter is bond would continue. And then in the case ending in 1460, count 1 is dismissed. And he'll continue his not guilty pleas as to counts 2, 3, and 4. Pretrial in that matter will be set for
21st at 10 a.m.
April 21st, 2025, 10 a.m. before Judge Washington.
Because if I could address that.
Of course you. Go ahead.
Yes. So given that there were several felonies that were dismissed, especially in regards to case number ending in 1442, Mr. Love now faces a 93-day misdemeanor. He has been incarcerated since, I believe, February 14th, Valentine's Day, which is very fitting considering his last name is Love. But he has been in custody now for about 40 days, 45 days now. So given that he's served about 45 days on a 93-day misdemeanor, we'd ask the court to consider a personal bond. And I'd ask the court to consider a personal bond on the other case as well. He is 31 years old. Should he be released, he would be residing in Milan, Michigan with his brother. His brother is present in the courtroom. His brother has been actually present at all of the last court hearings and is very supportive of him. He does have employment lined up at Best Games. He would be working full-time there as a manager. It's my understanding it was confirmed that job is still available for him. He has 2 children. He has a high school diploma. He's very much involved in nonprofit, working with churches and helping do advertisements for the churches. He also has a connection to potentially secure alternative employment at Milan Metals as well. So we would ask the court to consider personal bonds on these matters. And we'd suggest any risk to the public or flight could be accomplished via a tether.
Respond to the people.
No, I'll leave it to the discretion of the court. We would ask for the tether.
And you do understand, sir, that there is a no contact with Ms. Nobles.
Yes, Your Honor.
All right. Set his bond in each of these cases, $5,000 personal recognizance bond. Will also indicate that the defendant is to be placed on a GPS tether location tracking.
Thank you very much, Judge.
All right, thank you.